In Texas, when a lender decides to foreclose, they don't need a judge. They don't need a courtroom. And that can be done in as few as 41 days. I'm Hamilton Rucker, Texas real estate attorney, and today I'm going to walk you through every step of that countdown. What happens, when it happens, and what your options are at each stage. Whether you're a homeowner or you just missed a payment, an investor buying an auction, or someone who simply wants to understand how Texas foreclosure works, this video is for you. Foreclosure in Texas, the 41-day countdown. Today, we're covering the entire Texas non-judicial foreclosure process from the moment a default is declared to the day a property sells at auction. I'm covering the rights you have along the way and how to stop the process if that's your goal. Let's get into it. Texas moves fast. The non-judicial process. First, understand why Texas is different. Most states require a lender to go to court to foreclose on your home. That process can take a year or more. Texas allows non-judicial foreclosure, meaning the lender exercises power of sale clause in your deed of trust and moves forward without a court order. The trustee, typically a law firm or title company appointed by the lender, carries out the sale. There are strict rules about notice and timing, but those rules work on a very compressed timeline. This is one of the fastest foreclosure states in the country. That is not a mistake. It's by design. And if you must act fast before you fall behind on any missed payments. What starts the clock? Well, what starts the foreclosure clock? Default. A monetary default is the most common. You miss one or more mortgage payments and the process begins. But there are also technical defaults. Failing to maintain property insurance, not paying property taxes, or violating terms of your deed of trust in other ways. When a lender identifies a default, they conduct an internal review. They look at the payment history, the loan balance, any applicable loss mitigation options, and then they decide whether they want to proceed. Once they decide to move, the process begins immediately. Most loan documents include a grace period and require the lender to provide notice. But once they're moving, time is critical. Step 1, the warning shot, notice of default. The first official step in the notice of default under Texas law, the lender must send you written notice of default by certified mail. This letter identifies the specific default, the missed payments, the amount owed, and it gives you a chance to cure the default before the process escalates. Texas law requires a minimum 20-day cure period after notice of default before the lender can accelerate. Here's the critical point about this notice. Open your mail. I know that sounds simple, but I've worked with many clients who let certified letters sit assuming it was just junk mail or hoping the problem will go away. It doesn't just go away. The letter starts your window. 20 days goes fast, and if you can cure the default, catch up on payments, fix the insurance issue, whatever the problem is, do it now within this window. Step 2, calling the full loan due. If you don't cure the default during the 20-day window, the lender sends an acceleration notice. This is the moment the entire remaining balance of your loan becomes immediately due. Not just the missed payments, but the entire loan. So, for instance, if you owe $180,000 on your mortgage, the lender is now saying, pay us $180,000 in full right now. You would need to pay the full accelerated balance, negotiate a reinstatement agreement with the lender, or pursue another option like a loan modification or a short sale. The acceleration notice typically also starts the clock on the posting and notice requirements. The minimum timeline, 41 days. Here's the compressed timeline Texas law permits. Day 1, notice of default is sent. You have 20 days to cure. Day 21, if uncured, the lender can accelerate and file the notice of sale. The notice of sale must be posted at the courthouse and filed with the county clerk at least 21 days before the foreclosure sale. Day 42, at the earliest the foreclosure sale occurs. That's it. From the first notice to the auction, the entire process can be completed in 41 days. Most lenders take longer in practice. There are internal processes, notice requirements, and sometimes loss mitigation that allows things to slow down. But legally, 41 days is all that stands between you, a missed payment, and losing your property at auction. This is why acting immediately is not just advisable, it's essential. Going public, the notice of sale. The notice of sale is the lender's public announcement that your property is going to auction. Texas law requires the trustee to post a notice at the courthouse door of the county where the property is located. File it with the county clerk and mail a copy to you at your last known address. This posting must happen at least 21 days before the scheduled sale date. Foreclosure sales in Texas happen on the first Tuesday of every month. That's a Texas-specific rule baked into state law. So if the lender posts notice on September 10th, the earliest sale date is the first Tuesday of October. The public posting is what enables investors to find out about upcoming auctions and do their due diligence on the property. The first Tuesday, the foreclosure auction. The foreclosure sale itself takes place on the first Tuesday of the month, between 10 a.m. and 4 p.m. at the location designated in the original deed of trust, traditionally the courthouse steps, though the actual location varies by county. The sale is a public oral auction. Bidders must have certified funds, cash equivalents, ready to pay, full on the day of the sale. There is no financing at a foreclosure auction. Third-party bids exceed the amount, the lender takes the property back as a REO, real estate owned asset. If a third party wins the bid, then they get a trustee's deed at closing. Foreclosure sales come with significant title risk. Junior liens, unpaid taxes, and other encumbrances may survive the sale depending on the circumstances. The lender will typically open bidding at the amount of the debt that is owed. How to stop the process. If you're facing foreclosure, you have options, but time is a resource you cannot replace. Option 1, you could pay off or reinstate the loan. If you can raise the full accelerated balance or negotiate a reinstatement agreement with the lender, the foreclosure stops. Lenders are often willing to negotiate payoff amounts or loan modifications if you engage them early and in writing. Do not wait. Option 2, file for bankruptcy. An automatic stay under the federal bankruptcy code halts virtually all collections actions, including foreclosure, the moment you file. A Chapter 13 bankruptcy in particular allows you to restructure your debt and catch up on arrears over a 3 to 5 year plan while keeping your home. This is a serious legal process with long-term consequences. Consult a bankruptcy attorney immediately if this is your route. Option 3, file for a temporary restraining order. If the lender failed to follow proper notice procedures or if there are grounds to challenge the foreclosure, a TRO from a Texas court can halt the sale. This is a high bar and requires immediate legal action, but it has stopped many improper foreclosures. Special rights and protections. Texas and federal law provide special protections in certain situations. If you are active duty military, Service Members Civil Relief Act, the SCRA, provides significant foreclosure protections, including a right to request a stay of proceedings and a cap on interest rates. These rights require you to notify your lender of your military status. They are not automatic. Texas also has unique rules for home equity loans. If you borrowed against the equity in your primary residence, the foreclosure process has additional constitutional requirements and must go through a court in certain circumstances. This is a specific area of Texas law that can work in your favor if it applies. Tax lien foreclosures, where a taxing authority forecloses for unpaid property taxes, operate on a different timeline and invoke redemption rights. If you're facing a tax lien sale, the rules are different from a mortgage foreclosure, and you have a specific redemption window after the sale. After the sale, what happens next? If the sale goes forward and a third party or the lender acquires the property, there are 3 things the former owner needs to understand. First, eviction. Once the foreclosure sale is complete, the new owner has the right to possession. They can begin eviction proceedings immediately. Texas evictions can move fast. We're talking weeks, not months. If you're still in the property, negotiate a move-out agreement, cash for keys, rather than waiting for a constable to remove you. Second, deficiency judgment. If the property sells at auction for less than you owed on the loan, the lender may sue you for the difference. That's called a deficiency. Texas has some protections around the fair market value, but a deficiency judgment can haunt your finances for years. Get legal advice on this. Third, surplus funds. If the property sells for more than the total debt, you may be entitled to those surplus funds. Many people don't know this. If your property sells at auction for more than what was owed, claim those funds. Contact the trustee immediately. So here's some key takeaways. Let me leave you with 4 things that you need to remember. 1, act fast in Texas. You do not have the luxury of time. The moment you fall behind, you need to be evaluating your options. 2, open your mail. Certified letters from your lender or a law firm cannot be ignored. That notice starts a legal clock that keeps running whether you acknowledge it or not. 3, strict compliance cuts both ways. Lenders must follow the notice requirements precisely. If they don't, wrong address, improper timing, failing to file correctly, you may have grounds to challenge the foreclosure. An attorney can spot these issues quickly. 4, seek help early. The further you are from the sell date, the more options you have. If you wait until the week of this auction, your options collapse. Engage a Texas real estate attorney the moment you receive a notice of default. So if you or someone you know is facing foreclosure in Texas, or if you're an investor looking to understand the auction process, you can reach out to my firm. We are Texas real estate lawyers, and we can help you understand exactly where you stand and what your options are. The link to our firm is in the description. Subscribe for more Texas real estate law content. New videos are coming out every week. And I'm attorney Hamilton Rucker. Know your rights, act fast, and don't face Texas foreclosure alone. Thanks.